Per pretrial, he's tested positive presumptively because they have to send him to a lab for confirmatory for alcohol and THC. I think they described his behavior as
Threatening.
well, I didn't get threatening, but
I got threatening.
Okay.
And I'm going to tell you now, I'm not going to have you, and I'm not going to stand for your threatening anyone in this court at any time. That is, every part of this is an extension of us. I don't care where you're going. I don't care what building you're in, whether you're in pretrial services, whether you're taking a drug test. It's unacceptable, and I'm revoking your own, and he now goes with you.
if I can judge, I don't believe there has been actually any evidence presented to warrant a verification.
She told me yesterday that there had been multiple threats.
So, all right, to circle back, there's a couple things. In speaking with pretrial, I have not received any information about threats. I've received information about cursing and rude behavior.
Yes, Judge. There was no threat of harm or anything like that. It was just more so attitude. He was thinking people in our office a little bit uncomfortable just with his demeanor and the things that he was saying, but none of it, to my knowledge, has been anything, putting you in danger, threatening danger, anything of that sort.
This is where
You have an open criminal case. You're to be humble and contrite. And when you're not, and when you're threatening, abusive, harassing, I'm going to take care of you and I will light you up like a damn Christmas tree. Do you understand? It is unacceptable, the behavior that you have displayed here with myself, with pretrial, with the people down over there. And if you don't straighten up and fly right, I'm going to be all over you. Do you understand? Sure. One false move again. This is not supposed to be a happy time for you. And I don't know what I need to do to get your attention. But next time, I will classify you as a danger, revoke your bond, and make it so high you will have teeth falling out. Do you understand?
Sir.
Take a seat.
Thank you, Judge. Back to the point. Do you have a preference on a reset date, Judge?
So tell me what he tested positive for.
It was PhD and alcohol.
This is where I'll add that the court added bond conditions yesterday, so he had the magistrate.
I understand.
Okay.
He did his magistrate orders in October. Then I did see that he was instructed over. I didn't have the alcohol digits from this.
October what?
October
14th, 15th.
Give me the last name again.
Bledsoe, BLED.
Oh no, he's still smoking weed then. I mean, if they told him not to use any kind of illegal drugs, and he tested positive right now, give me the date, please. Come up, Mr. Bledsoe. You're not off the hook yet.
This is where I will repeat my assertion that since he's out on bond, he's entitled to a hearing where the rules of evidence would apply.
What we're doing right now.
Well, then I'm going to object to hearsay to anything and everything being heard by the court.
What day was the magistrate condition for no using, please? October 20th.
I also give my spiel about THC seltzers that I could buy at Specs that have no alcohol but have THC in them.
You are not to use alcohol. You are not to use illegal drugs. I'm going to give you the benefit of the doubt, and I'm going to test you again in 2 weeks from today. If you test positive for THC again, and I don't care what it is, I don't care if it's a gummy, I don't care if it's a joint, I don't care if it's Delta 8, if it's Delta 9, if it's Delta 352, whatever it may be, you will stay with me. Do you understand?
Yes, sir.
Get whatever records you need. But if you test positive for THC again, you're on notice now. You will stay with me.
Yes, sir.
Okay.
Thank you, Dad. Have a seat back in there. Come on. But did you have a preference on the reset date?
2 weeks, whatever you want.
Oh, yeah, I'm sorry. You're right. You said
I'll test them back and we'll see. By then it'll be sufficient benefit that there's just no argument.
Do you want him 2 weeks from today testing on that date? Okay. Will be. Thank you.
A tense pretrial hearing escalated when a judge sharply confronted a defendant who tested presumptively positive for alcohol and THC while out on bond, amid complaints of rude, abusive, and allegedly threatening behavior toward court and pretrial staff. Although officials clarified no direct threats of violence were documented, the judge made it clear that any hostile conduct is unacceptable, warning that all interactions inside or outside the courtroom fall under court authority. The court stopped short of immediate bond revocation, instead issuing a final warning, reinforcing strict bond conditions prohibiting alcohol and illegal drugs and ordering another drug test in 2 weeks. The judge emphasized that any future positive THC result, regardless of form, will result in immediate detention, making this hearing a critical turning point in whether the defendant remains free or is taken into custody.
For sure, Nate.
I have no idea, sir.
Either you're continuing to use or you just don't care about court orders. I've ordered you not to use. We're now working. When did we order him not to use? What was the day?
I've been on this case a while.
His case has been open since February. The end of February. Say it again?
February 26th.
Yeah, February 26th. We're now April 16th. It's been 51 days.
Oh, you did.
Yeah.
I'm putting you in jail. I told you not to use. You're continuing to use. Okay.
And I know how the court generally feels about the prescriptions for the marijuana, but he does have a valid prescription.
Nevertheless, I told him not to use.
He's gained an employee judge, which when we came here previously, you had ordered him to get a job, which he did. And of course, he's brand new at the job. And if he goes into custody, he's most certain to lose that job.
Michael, I don't want him to use. What else am I supposed to do? I don't care that you're now working your second criminal case within the last year, you know? Give an assault from 23. Now you've got a theft.
One more opportunity, Judge.
How long am I supposed to give him, Malcolm? Another 30 days for him to just continue smoking weed and just
Test him in 2 weeks, Judge? Or even, I don't know if next Thursday will be too soon for the levels to go down. I'm not really.
Do you have levels now?
No, not at this time. This is a rapid test that needs to be confirmed in the lab still.
If you want me to give you the benefit of the doubt of next Thursday, I will do it. You must be here Thursday. If you test positive for weed, it's not going to go well for you. I've harped on it over and over and over.
Yes, sir. Judge, and I don't know the science. Is what currently in his system, would it be gone by next Thursday? Or would it still be in his system who tests
If he
positive?
continues to smoke, then no. But by then it'll be 2.5 months. So if it's still in his system, that tells me that he's continued to smoke weed while he's on bond. You know,
Yeah.
there's only two things. It's either in your system or it's out of your system.
I don't smoke, so I got THC tinctures.
What's
I
that?
don't smoke flower. It's not a flower.
You're not supposed to use anything that has THC in it that could cause you to test positive. You know exactly what you're putting into your body. You know exactly what I've ordered you not to do. We'll put you on for this Thursday. I don't know what else to tell you. I mean, you want hieroglyphics? Perhaps Mandarin? I don't know what else. I'm speaking English here. I've told you what you can and can't do. That's it. I'm going to give you the benefit because of Michael that you got until next Thursday. If you continue to test positive, it's just not going to go well. All right.
Yes,
See you
sure.
Thursday.
Thank you, Judge.
All right.
In a firm and escalating bond compliance hearing, the judge ordered a defendant taken into custody after repeated positive THC results, making clear that court orders had been ignored for over 51 days since a no-use directive was issued on February 26. Despite defense arguments citing a medical marijuana prescription and recent employment, the court emphasized that bond conditions override prescriptions, especially with multiple pending criminal cases, including prior assault and a new theft charge. The judge stressed that the issue was not confusion, but continued noncompliance, stating the defendant knew exactly what was prohibited and chose otherwise. In a final act of leniency, the court granted one last chance, ordering the defendant to return the following Thursday for testing, warning unequivocally that any remaining THC in any form would confirm ongoing use and result in immediate jail, marking this hearing as a decisive moment in whether the defendant remains free or is remanded into custody.
Monitor, and I got that waived, but there was an issue with the back pay. For some reason, it wasn't waived to begin with.
Guys, I see he's got a felony warrant.
There wasn't one. I checked about an hour ago. Okay.
He's on probation for credit card abuse, picks up this assault, and I'm looking now, there's a felony warrant for an assault on a security officer, assault of a peace officer.
That case has already been open. And he's been.
I remember it being open. I remember that we've had issues with this, but maybe I'm wrong. I don't know. Regardless, I mean, we're going to do this now. It's just that if there's an open warrant, I'm going to have to take you into custody. I don't know. It appears to be so, but the computer's been wrong before. Yeah. Take your time. No rush. Mr. Miller, you're charged with assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 4 days in jail with credit for the 4 days that you've done. You need to understand that by pleading guilty to this offense, there are consequences that may arise. If you're on probation or parole, this can be used against you, which would result in further confinement. Do you understand? Yeah. Do you still want to go forward with this?
We'd like to see you check for the warrant. I mean, if he's going to be going in, and we may want to hold off on the plea today.
Okay. It's up to you here.
Who is issued to the judge? For himself.
It's weird because when I looked earlier this morning, because I knew he had bond violations here. The reason you're here now is because you have bond violations, right? And when I looked earlier, there was no warrant. Yeah. And when I just pulled it up now to look, a warrant has been issued. They issued a warrant 8 minutes ago. And we don't does this give a reason why?
Bond condition matters.
There you go.
Okay.
Mr. Miller, when you're on bond, there are conditions that you must follow. And when you don't, there are consequences.
As right was going, it is not current. It's sitting on the judge's thing to be something.
He's saying it's.
They issued it as a court, but it hasn't been signed. So
that's where I'm seeing it, but it's not showing up in the just.
I need to know what you want to do. Do you want to go forward with this plea, or do you want to?
Will he be going into custody because he hasn't been signed yet?
He's got bond violations with me. He's on probation. Picks up a case. Now he picks up a felony case. He's got bond violations with me.
Yes, but if we did the plea and here the bond violation too.
Yeah, if you do the plea, then you do the plea. It's up to you guys.
Signed.
Yeah,
okay.
If it's not signed, no, because we can't do anything to.
What I will do, I will just verify this to make sure if he can be able to probably just call in.
I would just be, Mr. Miller. So you're skirting a very thin line, man. You know, you tell me what you want to do.
Well, if he can leave today, I think that's what you would like to do. Is take the
if we do the plea and she hasn't signed it, I have nothing to hold him. But you need to understand that it may at some point happen. So
he does have court for this case, that the felony case next week. So that would give him some time to get something set up with a bondsman and get something worked out.
I don't know. So do you still want to go through with this, Mr. Miller? So yes. Okay. So you were charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 4 days in jail, credit for the 4 days that you've done. Understand that, like I told you, there are a lot of rights that you're giving up. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you can never take this back. It will go on your record and it's going to be there forever. From now on, you're facing a minimum of 90 days in jail. Do you understand? If you're on probation or parole, you also need to understand that by pleading guilty to this, they can revoke that probation or parole and it can result in further confinement. Do you understand? Do you still want to do this? Okay. How do you plead to the offense of assault, bodily injury, guilty or not guilty? I'm going to find you guilty. I will follow the agreement, sentence you to 4 days in jail. I will give you credit for the 4 days that you've done. I will roll your court costs so you won't know anything. And good luck to you, sir.
In a tense and fast-moving courtroom moment, Mr. Miller's bond violations escalated into immediate legal jeopardy when a newly issued felony warrant surfaced mid-hearing, tied to an alleged assault on a security or peace officer, while he was already on probation for credit card abuse. Despite confusion over whether the warrant had been formally signed, the judge made it clear that Miller was walking a razor-thin line, facing compounding consequences from multiple cases, probation status, and pending violation. Choosing to proceed, Miller pleaded guilty to assault bodily injury, fully warned that the conviction could be used to revoke probation and lead to further jail time. The court accepted the agreement, sentencing him to 4 days in jail with time already served, waiving court costs, and issuing a blunt warning that future missteps could trigger far harsher outcomes, closing the hearing with a stark reminder that leniency is running out.